if you are a landlord or a tenant in England, you probably heard about the Renters' Right Act. It's probably going to be the biggest change in the property sector for the last 30 years.
We're talking about today the end of fixed-term tenancies, the abolishing of the Section 21 notices, no-fault evictions, and new rules around the rent increases, stricter responsibilities for landlords too. So the way renters work in England is about to change quite significantly.
And we noticed that a lot of landlords and tenants are asking always the same question lately to us. Will I need to sign a new tenancy agreement? Will the existing tenancy agreement be valid? Or can the tenants leave whenever they want? Lot of questions they ask are similar to this line. Or how will eviction work in the future? Right?
Exactly, Matteo. So in this video today, we're going to walk through key changes step by step, explaining what exactly it means in real life and highlight the things landlords should start preparing for right now. So even for tenants too, this is really, really important information.
Right, so let's start. Let's go straight to the point. One of the biggest points is related to the length of the tenancy. Like when I was a tenant, I used to sign contract or tenancy for 12 or 24 months with 6-month break clause. What is happening now?
So under the new system or the legislation, fixed term assured short hold tenancies will effectively disappear. Instead, tenancies will move into open-ended structures. What it means is that tenancies continue indefinitely unless the tenant decides to leave or the landlord has legal grounds for possession.
So tenants, technically, they can stay as much as they want.
Absolutely. In principle, but it's also important to understand that landlords still have legal routes to regain possession of their properties as well.
So what about then tenants living? If I'm a tenant, can I leave whenever I want?
So that's a good question, Matteo. Tenants will be able to leave with 2 months' notice. This does create a bit of a different dynamic compared to the fixed-term contracts that we used to have, which is why tenants referencing and screening becomes even more important for the new position,
so it's
for the new system.
Very important to screen the tenants to make sure that it's going to be a good one.
Exactly. So this is why we always say having the right tenant is the most important part.
To make sure that they stay as long as possible, right?
Or as long as you want them to stay for.
Right.
So this is why it's so important for landlords to really have this.
And what about the existing tenancy? Do they need to sign a new contract from 1st of May?
So no, existing tenancies will automatically transition into the new system, which is the APT. So landlords will genuinely won't need to issue any new tenancy agreements to the original ones that they've got. However, it is still wise for landlords to review their documentation and procedures because the way of possession will change.
Right, and one of the most talked about topic about the reform is the abolition of Section 21, often called the no-fault eviction. What is actually happening in the future?
So Section 21 notices are being abolished. So they're no longer, absolutely nothing again. This means that landlords will no longer be able to end a tenancy without giving specific legal reasons behind it. Up to now, a lot of landlords could regain possession simply by serving just 2 months' notice, and that's it. And that would be justifiable. But the option will now disappear. So no more Section 21 notices.
Okay. So how will landlords regain their properties if they want to?
So possession of a property will now be legally on the grounds for possession. So some of the most common will be including the following. So if a landlord intends to sell a property, it is 4 months' notice. Or either members of their family intend to move in, or serious rent arrears, or antisocial behaviours, or either serious criminal activities. Each of these grounds has its own notice period, evidential requirements will need to be also cased too.
So it's not like a landlord cannot regain the property anymore. They just need to follow legal grounds.
Precisely. So this is exactly it. And in practice, this means documentation and proper processes become a little bit more important. So for landlords, it is really, really clear to them that they've now got to do it correctly. And they cannot be doing things just whimsically.
Okay.
They need to do it really, really in detail.
And we said that if I want to repossess, to sell the property or to move in a family member, I will need to give 4 months notice to my tenants. But what if they just signed the contract the 1st of May, just the other day? What will happen? Can I just give them notice the first day of tenancy of 4 months?
A lot of landlords think that they can just give 4 months notice right from the start of the tenancy. That's not the case. So what happens is basically, if let's say you as the landlord wanted to sell your property, what that would mean is that you would need to give, if you started it on the 1st of May, when the reform bill comes in, you need to give the tenant at least a minimum time in the property of 12 months.
Right.
And then after that, you can then give them, or you can serve them 4 months notice with gaining possession with something called a Section 8 notice,
right,
with grounds for possession.
Okay, so we give the peace of mind to the tenants for at least 12 months.
At least 12 months, but to be perfectly honest, at least 16 months.
Yeah, true.
So if that is obviously that you're wanting to sell the property, you've got to bear in mind that if you have a tenant that is moving in tomorrow or whenever they're moving in, they've got to be really, really careful that, or the landlords have got to be really careful that they do not want to sell it in the first 12 months or the 16 months.
Right.
They can only sell it once that 16 months is up.
Okay, understood. And let's talk about rent increases. What is changing there?
So good question. Rent increases will be becoming more structured and regulated. So landlords will genuinely be able to increase the rent once per year, and increases must follow a legal process. That's really, really important. That usually involves serving something called a Section 13 notice on the tenants once per year if you're wanting to increase the rent.
And the landlord will need to justify the increase.
Yes. So the process of rent must be reflected by the market value.
So landlord will need to prove to the tenants that there are the right amount of comparables proving their points that the rent is going to be increased.
Yes.
Right.
Yes.
And what happens if the tenants dispute the rent increase and they're not happy with that?
So in the case that obviously the tenants dispute it, then you can refer to something called a first-tier tribunal. This is free for landlords, and they will review the case. The tenants will still continue to pay the existing rent until the decision is made by the first-tier tribunal.
Right, and the other big topic is the ban on bidding wars. I remember when I was younger, looking for properties, there were some cases in which I would go to see a property, let's say, advertised for $1,500 a month. You go there, and then the estate agents will say, look, have you seen how many people there are? I think you need to offer $1,700 to get it. So we were ending up offering above the asking price the day after.
Just to be able to get the property, right?
Just to be able to get the property. What is going to happen now?
So under the new rules, landlords and agents must advertise a clear asking price on the property and cannot, by any circumstances, encourage tenants to bid above it. The aim is to basically protect the rental process and make it a little bit more transparent and also fair too, I think.
But tenants can still voluntarily increase their offer if they want to without nobody telling them to do that.
Yes. So technically they can, but landlords and agents cannot encourage higher offers. So they are not allowed to say, for example, if you as the tenant said, and to me as the landlord, I would like to take this offer or I'd like to take this property and it was on the market for 1,700, but you were happy to offer 1,900, and you physically did that yourself, that's absolutely fine. But if I, as the landlord or the agent, then suddenly said to you, Matteo, as the tenant, you know what, you will be able to take this offer, or you'll be able to take this property for 1,900, or if you offer £200 more per month, that's not allowed.
It's illegal. Right, understood. Let's talk about the AWAB's law.
Yes, let's
which
do
has
it.
received a lot of attention in the news lately.
Yes, absolutely. Arab's law is unfortunately something that's really, really horrible, but it needs to be talked about. It's a tragic death of Arabashak, a 2-year-old child who died after prolonged exposure to mold in his home. The law aims to ensure, or the law is aiming to ensure, that tenants are never left leaving unsafe conditions or living in unsafe conditions.
And what does it require landlords to do?
So landlords will legally require to investigate and fix serious hazards within a strict time frame. So this is very important. For example, issues like damp or mold must be addressed quickly, with investigations typically required within 14 days. So you have to, for example, if you had a property, Matteo, and there was mold in the property and you had a tenant, you have 14 days to act on the mold to be able to remedy that mold. If it takes a little bit longer, and if there was a building where it's coming from the external of the building, you need to have hard evidence, guys, that it shows that you are acting within those 14 days.
Okay, this is a very big part of legislation.
It's very important, probably on the lines of obviously the most important one. Yes, I fully agree.
Another topic that people are discussing is the right to request a pet. Many people in London have a pet nowadays. What is changing in that regard?
Tenants can have the right to request permission to keep a pet at their property, of course, and landlords cannot unreasonably refuse the request. However, landlords still can refuse if they have legitimate reasonings. That is the most important part about it.
Okay, so for example, what would be a valid reason for a landlord not to accept a pet?
So valid reasonings might include the following. So the property being unsuitable for particular animals, or insurance restrictions. So building insurance restrictions on the actual policy itself with the actual lease itself of the property. Understood. So these ones are obviously the most common ones to have, but also if there is damage that it can cause to the property itself, they can also retract on that too. Yeah,
for instance, if I'm renting a studio flat and my dog is a San Bernard, that could be a good excuse because it's too big for the property.
Exactly.
Right? So,
like if you have a Saint Bernard, those ones are huge. They're absolutely massive dogs, and you can't have it in a 1-bedroom or a studio. That's not physically possible.
Right. No, it makes sense. But I heard also that landlords can request their tenants to pay for a pet insurance that cover the damage that the pet might have done, right?
Yeah, so landlords can request for this. They can say to the tenants that if they want to have a pet and it is reasonable size and it fits all the criteria, that they ask for a pet insurance from the tenants for any damages or losses to the property if that does occur. So that is very important, I think, for tenants to understand, but also to landlords, that obviously you don't always have to say or accept pets, but if you do accept pets, you can also request for this to happen too.
So another structural change is the creation of a new private sector ombudsman.
Yes.
Right? Tell me a little bit about that as well.
So what will be happening is that it allows both tenants and landlords to resolve disputes without going to court. So in addition, landlords will be able to require or they will have to require to register on a new property portal, which will improve transparency and compliances across the sector. So this is very important, but, and I want to make this very clear, this is not happening straight away. This is going to be happening in 2028 or 2027. So it's not going to be happening on the 1st of May, 2026.
So we will have some time to get used to it.
Exactly, exactly.
But one final important point is that landlords, reflecting all these changes, will need to provide their tenants with mandatory informations in writing, right?
Yes. So landlords will be required to serve official Renters' Rights Act information sheet, which explains the tenants' rights under the new system. This document can be downloaded from the government website or the government portals, and landlords should ensure it is proven to the tenants that you have given this information to them. So it cannot be done by WhatsApp, can't be done via text, it has to be done via email. So it's probably around about 4 pages. And in those 4 pages, it needs to be given to the tenants before the 31st of May, not the 1st of May, but the 31st of May, to the tenants, and then it's proven via email that you've given it to them. With that, if you don't show this, there might be a £7,000 fine coming your way.
So you want to avoid that for sure.
Absolutely, absolutely.
Overall, this legislation is clearly going to reshape the rental market.
Yeah, look, right at the start, we say that it is 30 years of change here. Like, it's a big, big change to the property industry. So under the new rules and regulations, but the key thing for landlords and tenants to prepare themselves on is to maintain a proper understanding of the documentation, manage their properties professionally, and still operate successfully under the new system. That is hugely important, and I think that is something that everyone from our conversation today to really, really understand.
So you can find more information about the reform by reading our blog. You will see the link in the comments below.
If you have any questions about anything that we've gone through today or any of the changes that might affect your property or your tenancy, you can call the number on the screen or in the captions below, and we'll be more than happy to help. And if you prefer a more detailed discussion with us, simply use the link provided to book a guidance call, and we can go through everything with you.